An explanation of the plan to use the 14th Amendment to disqualify Donald Trump from the presidential race. Greetings to everyone. Today's video focuses on the exclusion of Donald Trump from Colorado's 2024 presidential ballot. This decision comes after a legal attempt, considered unlikely to succeed, was made in multiple US states to disqualify him from running for office. The basis of this disqualification stems from invoking a rarely utilized provision of the US Constitution, Section 3 of the 14th Amendment. This section prohibits individuals who have participated in acts of insurrection or rebellion against the country from holding federal office. Notably, this marks the first instance where Section 3 of the 14th Amendment has been employed to disqualify a candidate for the presidency. The adoption of this legal strategy gained momentum following allegations of election subversion against Mr. Trump in two separate criminal cases, which emerged in August. With no further delay, let us now delve into our discussion. In a surprising turn of events, a legal attempt in various states across the United States to disqualify Donald Trump from the 2024 presidential ballot has achieved an unexpected triumph in Colorado. In an effort to prevent Mr. Trump from appearing on the primary ballot, the strategy involves utilizing a seldom utilized provision of the US Constitution, specifically Section 3 of the 14th Amendment, which prohibits individuals who have participated in acts of insurrection or rebellion against the country from holding federal office. In the past few months, the theory has gained increased prominence, as it has been embraced not only by liberal activists, but also by some conservatives. This week, the Colorado Supreme Court made history by being the first to support the theory and decree that Mr. Trump should be excluded from the state's 2024 presidential ballot. This marks the inaugural instance in which Section 3 of the 14th Amendment has been utilized to render a presidential candidate ineligible. Until this point, previous efforts in various states to remove Mr. Trump from the ballot have proven unsuccessful. There is a concern among critics that allowing these cases to proceed may potentially deprive voters of their ability to independently decide whether the former president should be granted another term in the White House. The final decision will probably rest with the conservative Supreme Court, which was influenced by Mr. Trump. Following the American Civil War, the 14th Amendment was ratified, and Section 3 was utilized to prevent secessionists from reclaiming their previous government positions upon the reintegration of southern states into the Union. The utilization of this measure was directed towards prominent figures such as Jefferson Davis, the President of the Confederacy, and Alexander Stephens, his Vice President, both of whom had previously held positions in Congress. However, its application has been infrequent in subsequent years. The recent resurgence of this issue as a contentious topic in politics occurred following Mr. Trump's endeavor to overturn the results of the 2020 election, culminating in the violent insurrection at the US Capitol in January 2021. Following the chaos of the riot, the then President of the United States was impeached by the US House of Representatives for the specific accusation of incitement of insurrection. If the US Senate had decided to convict him, they would have had the opportunity to subsequently hold a second vote, requiring a simple majority, to prevent him from ever holding public office again. Contrary to expectations, the Senate was unable to achieve the necessary two-thirds majority to convict Mr. Trump, resulting in the absence of a second vote. However, Free Speech for People, an advocacy organization, has consistently maintained the position that there should have been a second vote. In the previous year, the organization lodged legal challenges against 5 lawmakers who were supporters of former President Trump, branding them as insurrectionists. The court case involving Georgia Congresswoman Marjorie Taylor Greene was brought to trial but ultimately resulted in defeat. Ron Fine, the legal director of the organization, argues that the 14th Amendment was intended not only for the post-Civil War period, but also for future instances of insurrection. In a statement to the BBC, he expressed that the US Capitol riot accomplished something unprecedented in our nation's history by obstructing the peaceful transfer of power, surpassing the progress made by the Confederates. According to Mr. Fine, the candidates we specifically contested in 2022 were involved either directly or indirectly in the activities that preceded the insurrection. Through his arguments, he asserted that all of these cases have set significant legal precedents, which can be utilized to demonstrate that Trump is the primary instigator of the insurrection. The recent removal of Couy Griffin, a county commissioner in New Mexico, from his position due to his involvement in the Capitol riot, marks a significant milestone. This ruling, carried out under Section 3, is the first of its kind since 1869. Similarly, in Colorado, a case challenging the eligibility of Mr. Trump was filed by the watchdog group Citizens for Responsibility and Ethics in Washington, CREW, on behalf of 6 residents of the state. In an additional effort, the group is individually requesting the removal of Mr. Trump from the primary ballot from election officials in a minimum of 18 states. This legal approach has gained momentum since August, following the filing of 2 distinct criminal cases accusing Mr. Trump of election subversion. In a law review paper penned by conservative legal scholars William Baude and Michael Stokes-Paulsen, it was asserted that Section 3 operates as a self-executing provision, resulting in an instant disqualification from office without requiring any further intervention from Congress. This declaration was made during the same month. Consequently, the conclusion reached by the duo suggests that Mr. Trump may potentially be disqualified from running for office. Both Mr. Baude and Mr. Paulsen, who are affiliated with the Federalist Society, a prominent conservative advocacy organization, have garnered support from other conservative legal experts, solidifying their stance. According to Jeffrey Sonnenfeld, a dean at the Yale School of Management who aligns with the Baude-Paulsen perspective, there is a possibility that the conservative-leaning Supreme Court, which includes 3 judges appointed by Trump, may be open to considering their argument. Given the impending Republican primary elections in less than 2 months, it is imperative that any case be resolved expeditiously. Critics have raised concerns regarding the feasibility of the theory as well as its suitability for implementation in an intensely partisan America. According to Chris Ager, the chairman of the New Hampshire Republican Party, attempting to prevent individuals from voting for their preferred candidates by employing convoluted legalistic reasoning is reminiscent of Soviet-style tactics and arguments commonly associated with banana republics. I want to make it clear that I don't align myself with any particular political figure, including Trump. My stance is one of neutrality, he emphasized. However, I strongly believe that this entire endeavor is detrimental to the well-being of our nation. The recent endeavor to undermine the electoral process by Donald Trump has been met with opposition from Brad Raffensperger, a Republican and the esteemed election official in Georgia, who has previously been subjected to Mr. Trump's criticism. Raffensperger dismissed this maneuver as nothing more than an attempt to bypass the traditional voting system. Despite facing numerous legal challenges, Trump continues to maintain a strong position as the leading contender for the Republican nomination. In fact, recent polls indicate a close race between him and President Joe Biden, setting the stage for an anticipated rematch. According to the Trump campaign, the legal challenge is being accused of distorting the law beyond recognition and is unsupported except by those advocating for it. The attorney representing Mr. Trump in the Colorado case put forth the argument that the simultaneous dismissals in Michigan and Minnesota indicate a growing agreement within the judiciary system. According to Scott Gessler, the individuals submitting the petition are requesting the court to take an unprecedented action in the entire history of the United States. However, based on the available evidence, the court is far from being able to fulfill this request. By removing Mr. Trump from the 2024 state ballot, the recent ruling by Colorado's Supreme Court has the potential to completely change the prevailing narrative. To support our channel's growth and ensure broader awareness, kindly hit the like and subscribe buttons. This will help us reach more individuals and disseminate valuable information. Thank you in advance.